Hey, Miss Holly.
Judge, how are you?
I'm good. How are you?
Doing wonderful.
Good.
Yes.
Glad I got you.
Yeah, I'm glad I have you.
Get my stuff on here. I was
Okay.
wondering where was everybody today. I was surprised.
They should be on right about now. It's
I
time.
don't see that many people.
No.
There they come. All
Okay.
right, hold on. Let me get my robe on.
Holly.
Yes.
So number one was released
Oh, wonderful. Okay.
according to Michael's email.
Okay.
Hold on. And number 17, I think.
Yeah, number 17, West. He was released as well.
Okay.
Thank you.
One and
Anybody
seven.
reset medical?
It may be number 4 again, unless his power of attorney waived his appearance because he had to go out with Grady, but they brought him back.
Okay.
Did anybody speak with Mr. Ferguson? You know,
That's what we
he,
was talking about.
Yeah, I tried to. I'm his attorney, and I went to go visit him today, and he would not see me, and he would not speak to me. I think he's going through a mental health episode.
so are you doing a waiver?
Um, at this point, I think we will waive first appearance.
You say you don't think you can?
I think we will be waiving first
Okay.
appearance.
Okay. Yeah, Mr. Ferguson is number 4 on today's calendar. Okay. Okay, so 1 and 17 have been released. Wonderful. Oh, and since everyone can hear me, the reset date for the SAP calendar is April the 8th.
Hey, Blunt, I sent you a message on the chat.
All right, you can go. You can go first if you want to, no matter.
Well, I think the judge still needs to make her announcements.
Judge, you got that 1 and 17 release?
Yes, I think one of my, hold on, my
Alright.
page is upside down. Or did it come out like that? Hold on, where's? My calendar is. Oh, that's how they are. Okay. We're ready to get started. All right, good afternoon, everyone. We're going to start our Fulton County State Court Expedited Accusations calendar. I am Judge Mincy, and this calendar is for cases in which individuals have recently been arrested and charged with certain misdemeanor offenses. Soon after their arrest, the Fulton County Solicitor General's office has already accused the cases of the offenses brought against them, and the case has been bound over to the Fulton County State Court. Nevertheless, this will usually be the defendant's initial appearance before a state court judge, so we are able to address several matters, including bond, possible arraignment, and a possible plea offer if one has been made by the state at this juncture. As you've already heard, the SAP reset date is April the 8th. And I want to begin by also reminding everyone that this entire proceeding is being recorded as well as live streamed on YouTube, so govern yourselves accordingly. I'm going to also remind those defendants on this calendar that you have certain constitutional rights. The first being that you have a right to counsel, representation at this point in your case. You should know who your attorneys are by now and have spoken to them. I also want to let you know that you have a right to remain silent. Remember that anything that you state about the facts, the circumstances, and the occurrences in your case can and will be used against you. The state is here and they're listening. So again, follow the lead of your attorney. All right. And who do we have first, deputies?
Good afternoon, Judge. This is going to be
Afternoon.
position number 16, but before we do 16, Ms. Welch, I do have a quick announcement for position number 14. Thornton, her bond has been paid.
14 is bonded out.
Yes, Judge.
All right, thank you. And this is 16 you stated.
Yes, Judge, that's correct.
Okay, to Kyla or to Kayla Welch. This is 25 CR 001575A. Charged with 1 count of simple assault, family violence, and a 2nd count of criminal trespass. Retrial.
The 5th arrest, 2024 affray, disorderly conduct. It's opening the cab and a DUI drugs. It's 2016 DUI conviction. That's it.
All right. State.
Good afternoon, Your Honor.
Good afternoon.
This is an incident from yesterday, March 25, 2025. Location, Ascent Midtown Apartments, located at 1400 West Peachtree Street, Northwest, Atlanta, Georgia, 30309, Unit 1515. The defendant, Ms. Takala Welch, and the victim, Mr. Silas Conley, live in the same apartment. The victim has been living there for the past 6 months or so. On the day of the incident, Mr. Conley moved the TV from the living room to his bedroom, and this upset the defendant, and they got into a verbal argument. The defendant told Mr. Conley to leave the apartment and to move out. According to the victim, the defendant asked Mr. Conley to give her the key fob, which is used to access the building. When he refused, the defendant grabbed a kitchen knife and threatened to stab the victim with it. Mr. Conley began to record the incident, and the police were able to see video of the defendant holding a large kitchen knife and screaming, "Give me the effing key." While screaming, the defendant moved the knife towards the door and with the tip of the blade caused scratches to the bedroom door. Mr. Conley told the police that at the moment he was fearful. We were able to speak with the victim, and he did confirm the events in the warrant. He said he's not afraid and that he will be okay with the defendant returning to the residence. He did not wish to be on Zoom today. Your Honor, the state's recommendation is a $5,000 surety bond, $4,000 for count 1, $1,000 for count 2, with conditions: no contact with Mr. Silas Conley, to stay away from Ascend Midtown Apartments located at 1400 West Peachtree Street Northwest, Atlanta, Georgia, 30309, Unit 1515, a social service visit, no drugs, alcohol, or weapons while on bond. We understand that the victim is okay with the defendant returning, but given the nature of the incident, the state's recommendation is going to be no contact at all with Mr. Conley and to stay away from the location.
Okay,
Good afternoon, Judge.
good afternoon.
Judge, on behalf of Ms. Welch, she's 33 years of age. I normally don't go into the facts, Judge, but this is actually her residence. He does not live there. He was there at the time. And I would just honestly, she's got a master's degree from Clark, Atlanta. She is a self-employed, has a clothing store, essentially, Judge. I would ask, I think she's eligible to be released through pretrial services, and that's what I would ask for. I'm concerned about the stay away only because that is her home, Judge. She's been living there for 3 years. So the request that I have for the court is to grant her signature bond through pretrial services, and allow her to have at least no violent contact, especially since that's what the alleged victim wishes anyway. But that would be the request of defense, Judge.
Well, it's difficult unless, and let me sound for the victim. Name is Silas Conley, just to make sure he's not here. And I believe, again, we don't normally put the victims out until we can hear from them or know what the situation is. And it appears that he was renting a room from her or something, so he's a resident there, is the information that I'm getting. And of course, they don't need to be together. I don't really care what they say. We need to make sure this is calmed down and that we're not going to have any further incidences at that location. I understand that it is her place, but I don't know. Usually sometimes I'll say we can go back and sweep the place if we know that the victim has said, "I'm moving out," or "I left yesterday," or whatever. But I don't have any information on the victim moving unless someone can tell me that.
I'm sorry, Your Honor, what was your question?
That the victim was also a resident there. Did the victim state to your office that he was moving or anything?
No, he stated that he lives there. He's been renting a room. Yeah, he's been renting it for the past 6 months.
Okay. Um, well, Ms. Welch, and I think, Attorney or PD Haddad, what I will do, I will give her a pretrial bond, the $5,000 bond through pretrial. And I will have her at a level 1. Also, that will be 4,000 on the simple assault, 1,000 on the criminal trespass. I'm going to, unfortunately, have to order that she stay away until we know that the victim has moved. And so you can ask for a modification at that time once we get that information. And State, I know you all have spoken with him, but he didn't mention he was moving.
He did not, Your Honor.
Okay.
Your Honor, it does sound like there might need to be an eviction here. It sounds like Mrs. Welch is going to have to proceed that way. He's a resident of the location, and it sounds like this argument included her demanding that he move out. So
Right.
that would be our recommendation, certainly, that he not stay there.
Okay. All right, so Ms. Welch, you will have to find somewhere else to go stay in the interim, because with this bond, you're to have no further contact with the defendant, Mr. Conley. And you're to stay away from that unit 1515. Also, there's to be no drugs, alcohol, weapons, or guns while on bond by you. So you have to stay 200 yards away from him, have no contact by email, cell phones, or anything while you're on this bond. If your attorney finds out that he has moved and that can be verified, or he calls in to the victim witness advocate at the solicitor's office and states that he's not residing there, then your attorney can apply for a bond modification. And then we'll look at that to see if we can then allow you to go back. But we have to know that the victim has vacated those premises first before you can go back. What I will do for you, Ms. Welch, is to give you a one-time law enforcement escort back to that property to get your personal belongings or clothing or things that you might need from that residence. But I'm going to tell you, you've got to schedule it with law enforcement when you get out. If you don't and you go back, you'll just be rearrested and brought back to the Fulton County Jail. A lot of people don't like to wait on that. They don't like to schedule it, and they want to think they can run back real quick and get their things. So please don't do that, because you'll end up back here. All right. Okay. I don't know that your attorney's going to want you to ask a question or not. Probably not.
Ms.
Talk to
Ms.
attorney
Ward, Ms. Welch, I can speak to you after court about that, Judge. But thank you, Judge.
All right. Thank you.
Thank you, Judge.
All right. Thank you.
Number 6, Ms. Lewis.
Okay. This is 25 CR 001578A, Monet Lewis. Charge of 1 count of battery, family violence, the 2nd count of cruelty to children in the 3rd degree. Pre-trial.
Hey, check your chat. Second arrest on probation for battery DV out of state court. It's 23 CR 001520A. That's all.
Right.
This will be my case, Your Honor.
Okay.
This incident date happened on March 24, 2025 at 3815 Roswell Road Northeast. Victim in this case is Abriana Jennings. That's Abreana Jennings. She stated that she was jumped by 3 individuals at the apartment, one being the defendant's boyfriend, and a friend that they had at the apartment. Upon officers arriving, she was standing outside, just wearing a shirt and pajamas. She had swelling to her right eye, blood to the white area of her eye. She also had a swollen nose with dry blood in both nostrils. She was supposed to be moving out and in contact with the defendant, who was Miss Lewis. Upon being in her room, which is across from the defendant's room, there was a knock at her door. She opened the door, and another co-defendant, the two other co-defendants were in felony court this morning, knocked on her door. Defendant was standing behind the other friend. She struck her, which started a physical altercation. At some point, she was held down by another co-defendant, which was a male, as this defendant and another co-defendant that is in felony court struck her multiple times. She stated she didn't have any underclothes on. The defendant pulled her pants down and bit her on her right thigh. While the other co-defendant choked her and held her down. She said she felt severe pain in her right thigh where she was bit. She showed officers her injuries. It looks like with this case, our office did have a chance to speak with the victim. She said they were roommates. She confirmed the events in the warrant. She stated they never had an altercation in the past, and she's upset the defendant was charged as a misdemeanor, as the other two co-defendants were in felony court this morning. She stated the defendant was the main aggressor and that they were all holding her down. She did state the defendant pulled her clothes off and told her boyfriend to have intercourse with the victim. She did state that she left this location and she wants no contact with the defendant. She stated she would be on Zoom so we could sound for her when appropriate. The state is looking for a $4,000 surety bond on this case. No further contact with the victim, Abriana Jennings. A stay away is not necessary if she has left the location, but I guess I would ask for a one-time law enforcement officers to confirm that Ms. Jennings no longer resides there. 1 day anger awareness and no drugs, alcohol, or weapons while on bond. And we sound for the victim when appropriate if she's on.
All right, is the victim Abriana Jennings on? Abriana Jennings,
Yes, ma'am.
you have to turn on your camera. I can't talk to you.
I'm trying to turn it on. I think it's okay. It's on there.
All right, are you driving?
No, I'm sitting right here parked in my dad's driveway.
Okay. All right, do you wish to address the court today, yes or no?
Yes, ma'am.
Raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, put your hand down for me. Are you in fear of Miss Monet Lewis?
Yes, ma'am.
Okay, do you want to have any further contact with her?
No, ma'am.
Okay. And you all were roommates?
Yes, we were friends before roommates.
Okay. And are you still residing at the location?
No, ma'am. That day I moved out, that the altercation happened.
Mm-hmm. Okay. All right, I don't have any further questions. State, do you all have any questions?
No, Your Honor, but then the stay away won't be necessary. She no longer resides there.
Okay.
There.
All right. And Attorney McLeod, you're representing the defendant?
I am, Your Honor. Good afternoon.
Good afternoon. Do you have any questions of the victim?
I do not, Your Honor.
Okay. All right. Thank you. Miss Jennings, you can mute yourself and then listen to the ruling. Okay. All right. Thank you. All right. Go ahead, Attorney McLeod.
Yes, Your Honor. My client is 23 years old. She has a 1-year-old child, she tells me, that lives with her. She also tells me that she lost her son some time ago. I think some months ago in last year, she lost a child. So she's currently in mourning. She is not employed, but she also tells me that she is also currently pregnant. I'm seeking a signature bond for my client. She only has one previous arrest, Your Honor. She has no significant criminal history and she's not working. If she doesn't get a signature bond, she will be stuck in jail and there will be no one to take care of her 1-year-old. So I believe she does qualify for a signature bond, and that is what I'm seeking for her today. She does, of course, deny the allegations in the warrant, and she tells me that she was definitely not the one who started this altercation. She was not the primary aggressor. Nothing further, Your Honor.
All right. If I think I remember correctly from pretrial, she's currently on probation.
That is correct, Your Honor, but she
For
only
battered
has one
family
cycle.
violence from last year. 2023 maybe. It's the same charge of battery family violence.
It's a simple battery family violence, Your Honor. I believe she's on probation for that from 2023, correct?
Yeah, and she's not working, 1-year-old, and she's expecting another child.
That is correct, Your Honor.
All right, I'm going to give her a signature bond through pretrial per judge. That will be a $5,000 signature bond. That will be 3,000 on the battery family violence and 2,000 on the cruelty to children, for a total of 5,000. I'm gonna order 2 days anger awareness through pretrial. That'll be a level 1. And
Judge, it probably at least need to be level 2. She already on probation for violence.
right, level 2. And I'm going to order that she have no further contact with Miss Jennings.
Judge, can I speak?
Let me give my ruling first.
Okay, I'm sorry.
She's to have no further contact with the victim, Miss Jennings. And I guess the stay away is not needed since Miss Jennings says she's already moved. No drugs, alcohol, weapons, or guns while on bond. And yes, Miss Jennings, what would you like to say
Your
briefly?
Honor.
Ma'am, I would like to say it's the fact that she get a misdemeanor when everyone was accountable for it. I got stripped within my clothes. I had no underwear on.
Okay,
At
hold
the
on.
time,
This is not, hold on. This is not a trial. This is a bond hearing. And
yeah, but
I don't bring the charges. I don't bring the cases. The solicitor's office does. So have you been in contact and talking with the solicitor's office?
she said she was going to reach out to someone else, and she told me to get on the Zoom call if I had any other questions.
Well, but we're
That's
going to ask those kind of questions on the Zoom call. These are questions related to bond and to the defendant, but those are not the type of questions that I would answer.
Ma'am, how did she get a misdemeanor when everybody else got a felony?
Again, I just told you, I'm not the charging entity. I'm the judge that facilitates this matter, but I do not make the decisions on the charges.
Your Honor,
That's what you need to talk back with the solicitor's office about, okay? I cannot answer that right now because that's not my lane right now.
may I, Ms. Jennings, our victim advocate will reach out to you regarding your questions.
I will
Okay?
hope so.
All right, make sure if they don't reach out to you, then you can call the solicitor's office and ask to speak to the person assigned to your case.
I sure will.
All right, good. Thank you. Take care.
Position number 8, Ms. Muhammad.
All right, this is 25 CR 001573G. Heaven Dream Muhammad, charged with 1 count of driving, striking an unattended vehicle and improper backing. Pretrial.
First.
All right, state.
Thank you, Your Honor. This incident date happened on February 10th, 2024 at 49 West Paces Ferry Road Northwest. It stated that two vehicles, were involved in collision. It happened in a parking lot. The victim's car was legally parked at this location. They went to handle some business in the area. Upon returning to her car, she observed that her vehicle had been damaged. There was a witness to the collision that left a note on her vehicle that she had recorded it. The defendant backed up into her car, which was a Volkswagen. She was driving a Nissan. She pulled forward, slowly drove away from the scene. And it looks like she stopped in the underground area of the parking lot and then pulled off. But upon the video, officers were able to identify her car and to call her into the police station. The state is looking for a $2,000 signature bond through pretrial on this case. No drugs, alcohol, or weapons while on bond. And that'll be it, Your Honor.
All right.
Your Honor, no objection to the state's request as far as a signature bond. If the court wishes to hear more about my client, let me know, Judge.
Your Honor, I apologize. And there will be a hit and run added to this count at a later date.
These are not bond restricted charges, are they?
They're not. I don't believe so, Judge.
Not for sure why we're bringing through pretrial. All right, I'm going to order the $2,000 signature bond through the jail. And that will be 1,000 on each charge. And I was going to say for this defendant, no driving unless they have the proper licenses and credentials, but I don't know that the license are suspended or not.
Yeah, I don't have anything in her file that her license is suspended, but if anything, we can add a no driving, I guess, without it if she does have a suspended license, but I don't have anything to notes that she has any use.
Judge, I don't believe, I mean, she informs me that she has a valid license. Obviously, if she drives that when it's suspended, that's a separate crime and she could get stopped.
And they
and
wasn't
arrested.
charged with that, right? All right, so if she's driving, just make sure that got all the proper credentials and licenses that are needed. And no drugs, alcohol, weapons, or guns while on bond. And I guess that'll be it.
Thank you, Judge.
Mm-hmm.
Number 9, Ashley Odom.
Hey, what was that bond?
That was 2,000 SOB jail.
And
Thank you.
And Your Honor, just so the court is aware, position number 8, I think Ms. McLeod maybe represent her. I'm not sure, but I represent position number 10, the other Ms. Odom, their co-defendants.
We just did number 8 with Muhammad.
I'm sorry, I think the next case is number 9. I apologize. Number 9 is in front of you right now, but I also represent number 10, who's the co-defendant.
Okay, gotcha.
I apologize. Thank you, Judge.
Oh, and they both have the same last names. I'm with you now. I'm looking there. Okay. All right, and this one, this is position 9, Ashley Odom.
Yes.
Okay. 25 CR 001563J, charged with 1 count of disorderly conduct. Looks like this is her first. Is that correct, pretrial?
Yes.
All right, thank you. All right, go ahead, State.
Yes, Judge. Ryan Sirocco on behalf of the state. Good afternoon. This incident took place, it was yesterday, March 25th, 2025, at 2323 Piedmont Road, Northeast Atlanta. That's AMLI Piedmont Heights Apartments. Law enforcement responded to a dispute call where the 911 caller advised they were being chased by a group attempting to assault her with a bat. Upon arrival, the officer spoke with the victim and 911 caller, Miss Grace Ellis, and that's ELLIS, who explained that she was walking her dog on a leash when, and this is since this is a dual arrest, when a Miss Janiqua Odom came from outside the location with her dog, small black dog, and upon seeing Miss Ellis's dog, ran towards Miss Ellis and her dog. Janiqua Odom became upset with Miss Ellis at that point and began to call others to the location. Following that, one of the individuals to show up was the defendant, who, along with others, began threatening to beat Miss Ellis and her dog up. They ran up on her dog, continued to threaten her, made racial comments to her, chasing her into the leasing office at the location. And yes, Judge, that is it with respect to this case and her history. If I'm not sure how you want to do this, but we can do it each time. We would sound for the victim if she's on. But she's the victim in several cases with multiple defendants today. So I guess we can hear from her now if the court would sound. But the recommendation from the state for this case is a signature bond through pretrial services, no further contact with Grace Ellis, and no drugs, weapons, or alcohol while out on bond.
All right. Is this Miss McLeod's or?
No case,
Which
Your
one?
Honor.
Okay.
Your Honor, I would ask for signature bond to the jail. My client did not threaten anyone or did not do anything at all. She denies the allegations. This was a dispute over a dog that had bitten my client's spouse. She did not threaten this woman. This woman's dog actually bit her spouse. There seems that this other person, the alleged victim, got very aggressive with my client, started using racial slurs, not only to my client, but to several others. Apparently, it was not just my client and her spouse who were arrested, but several others of the neighbors, because the alleged victim was the one who started all of this. Nobody just runs up to someone they see walking with a dog and start attacking them or speaking to them in a negative way. It doesn't make sense, the narrative that has been put out there. In fact, it's the opposite way around. This woman was the one who confronted the Odoms, not the other way around. And my client is not accused of striking anyone or making any threats or anything. I think they said disorderly conduct. She denies any kind of bad behavior, Your Honor. And I do not think that, given the fact that she has a totally clean record, she should have to go through the process of having to report to pretrial behind something that is more than likely going to go away ultimately, because it didn't happen the way the alleged victim claims it did. Nothing further, Your Honor.
All right. I will order a $3,000 signature bond through the jail. And with that signature bond through the jail is to I believe, does Miss Odom reside in this apartment complex?
She does, Your Honor. She lives there with her spouse and has lived there for several years.
And I guess this was out somewhere in the yard of the common area. You know,
Which is
it's hard to
correct, Your
say,
Honor.
stay away from the common areas. So she can go back home, but she should have no further contact with, is it Grace Ellis?
Grace Ellis, Judge,
Grace,
G-R-A-C.
G-R, I'm sorry. Yeah, I couldn't hear that well. Grace Ellis. No further contact with her. She is to stay 200 yards or 2 football fields away from Miss Ellis. If she sees Grace Ellis, she's to go the other way. No contact with through emails, no talking about it on Instagram or Facebook or any social media platforms. Do not discuss this case. Being admonished about that already. And again, no further contact and stay away from the victim. No drugs, alcohol, weapons, or guns while on bond. And that should be it.
Thank you, Your Honor.
Mhm.
Position 10.
This is 25 CR 001564J. Janiqua Odom charged with 2 counts of disorderly conduct and 1 count of dog at large.
Second arrest, 2016, given false name, shoplifting conviction.
Okay. State.
Yes, Judge. Again, this incident took place yesterday, March 25th, 2025 at 2323 Piedmont Road, Northeast Atlanta. The officers responded to the dispute, call where that 911 caller advised she was being chased by a group attempting to assault her with a bat. Upon arrival, they spoke with Miss Grace Ellis, who explained how she was walking her dog on a leash when the defendant came outside the location with her dog, who was off leash, and upon seeing Miss Ellis's dog, ran towards Miss Ellis and her dog. Now, when the officer spoke with the defendant, she admitted that her dog did run away from her and towards Miss Ellis. Miss Odom became upset with Miss Ellis, threatened to beat her and her dog up, and began to call others to the location. And once I got there in that mom, they continued to threaten to beat her up, ran up on her and her dog, and made racial comments to her. The defendant also spit in Miss Ellis's face and kicked her dog. It was reported as well, the defendant actually had to be pulled from Miss Ellis during the dispute. And she was ultimately chased to the leasing office at the location, as I've stated. As pretrial stated, prior theft by shoplifting and giving false info conviction from 2017. And from our contact with the victim, I would just say that if she's not on, again, we'd sound for when appropriate, but this is not the first encounter that our victim has had with the defendant. She's previously spoken to her. They've gotten to an argument about the defendant having an unleashed dog around the premises. And this is just the victim, this is the incident that escalated here. So with this, the state's recommendation as to the first count of disorderly conduct is a $400 good bond on the dog at large, a $200 good bond, and on the second disorderly conduct, a $400 good bond for a total of a $1,000 good bond, and with the conditions as well, no further contact with Grace Ellis, no drugs, weapons, or alcohol while out on bond. And I should have clarified this earlier, but the victim is actually moving out of the complex, so that is why we're not requesting a stay away here, Judge.
Okay. All right.
Judge,
Judy?
yes, Judge. On behalf of Ms. Odom, Judge, I second what Ms. McLeod mentioned earlier. My client and her spouse, who's Ms. McLeod's client, completely dispute the allegations, Judge. And I would point out that if anything, my client had a mini golden doodle, and evidence would show that, yes, perhaps was not on a leash. But I would also point out that the alleged victim had a pit bull that bit not one, but two different people, and also made the racial remarks towards my client and her spouse, and I think a couple of neighbors. I would ask the court, under the circumstances, and thankfully the alleged victim is moving, for her to be released through the jail, signature bond through the jail. She has minimal criminal history, Judge. She's self-employed as a photographer, and was also, when all this was happening, she actually had her 1-year-old that she was carrying with her when the victim just completely went honestly ballistic, Judge. So under those circumstances, I would just ask the court to allow my client to be released through a signature bond through the jail.
All right. And the victim is not on the call, is she? Grace Ellis? Okay. All right, I'm going to order a $2,000 signature bond. Well, let's make it $3,000 signature bond through the jail, $1,000 on each of the charges. And no further contact with the victim, Grace Ellis. And this defendant still has the dog. The law is the dog must be on a leash. So I'm going to warn her about it, and she needs to go buy one. Put the dog on a leash. Maybe won't have anybody else wherever you're moving to have issues with that. No drugs, alcohol, weapons, or guns while on bond. And I think that's it. Anything else? Did I leave out anything? Nope. All right, that's it. 3,000 SOB jail.
Thank you, Judge.
Okay.
Position number 19, Mr. Wortham.
Okay. This is 25 CR 001579J Darius Wortham, charged with 1 count of battery family violence, 2 counts of simple battery family violence, and a 4th count of, I'm sorry, 5th count of criminal trespass. No, I said it right. 4. 1, 2, 3, 4.
7 total. 2020 FTA, 2019 suspended license dismissed, 2019 driving with expired license no low. That's all.
Okay.
Yes, Your Honor. This case arises from 2 separate incidents. The first incident is from March 23rd, 2025. The location is a Shell gas station at 374 Cleveland Avenue Southwest, Atlanta, Georgia, 30315. The defendant, Darius Wortham, and the victim, Miss Sierra Bell, got into a verbal altercation. The defendant became very upset and slapped the victim in her face. The defendant then convinced Miss Bell to get in the car so they could talk. They ended up at an apartment. The warrant states that the apartment is where the defendant's brother lives. The defendant and the victim continued to argue. The defendant proceeded to punch the victim repeatedly. She left the apartment on foot, and the defendant followed her in his car. The victim ended up getting back in the car, and they ended up at the Shell gas station located at the address I mentioned before. According to the victim, she got out of the car, and the defendant tried to run her over with the vehicle. He then pulled out a gun and placed it in his lap, threatening her and telling her, if you don't get back in this car, I'll shoot you. Ms. Bell ran into the Shell gas station and called 911. The defendant was not on scene when the police arrived, but the officers did observe a large knot on the defendant's forehead. The second incident is from March 25th, 2025, so yesterday. The location is 65 Irby Avenue Northwest, apartment 917, Atlanta, Georgia, 30305. On the day of this incident, officers responded to a domestic dispute. Upon arriving, officers saw the defendant on top of the victim near the lobby entrance of the building. Officers were able to get the defendant off the victim and arrested him. The defendant had 2 firearms in his waistband and a brass knuckle in his pocket. According to the victim, the defendant wanted $500 back, which the defendant claimed were his. According to the victim, the $500 were hers. Ms. Bell left the apartment because the defendant was becoming violent and she was afraid since he had previously assaulted her on several occasions. She was sitting in the lobby when she saw the defendant with her work bag that contains her work laptop. When the victim tried to get her bag and the laptop back, the defendant punched her in the face and threw her on the ground. Ms. Bell had visible injuries on her face from this incident and also from the March 23rd incident. Your Honor, aside from these 2 incidents, there have been several other assaults against this victim. So the violence is ongoing. Additionally, the defendant has been calling the victim from jail. We listened to the calls and, he tells her that she better give him his money, or when he gets out, she's going to lose her home. She's going to lose everything, her job, her home. He also stated that he's not afraid of the police. We were able to speak with the victim and she confirmed the events in the warrant. The victim said that she is afraid for her safety because the defendant has been abusing her since October. The victim stated that she believes the defendant will kill her if he gets out. I believe she's currently filing for a temporary restraining order. And she definitely wants the defendant to stay away from her and her residence. The state's recommendation is a total bond of $13,000 surety bond, $5,000 for count one, $3,000 for count two, $3,000 for count three, $2,000 for count four, with conditions absolutely no contact with Sierra Bell, stay away from 65 Irby Avenue Northwest, apartment 917, Atlanta, Georgia 30305. No third-party contact. At some point, I believe the defendant's brother called the defendant as well. We're also asking for the defendant to surrender his firearms, no drugs, alcohol, or weapons while on bond. I believe the victim said she was going to be here and wanted to speak. If we can sound for her when appropriate. Sierra Bell.
Sarah Bell. Do you wish to address the court today, Ms. Bell? Can you hear me, Ms. Bell?
Yes,
Hold on
I
a
do,
second. Hold on
I
a
do,
second. Hold on a
okay,
second. I have to swear you in first. I'm looking at, looks like your camera's frozen.
okay, I'm trying to change the settings.
Or maybe that's your screen. Are you on two devices? Or just one? All right, Ms. Bell. Did she drop off?
Hi, I, was
Okay.
actually trying to say,
Hold on. I've asked you to hold on a minute. I need to swear you in first. My first question was if you wish to address the court today, I need to see you. Okay? So
okay,
raise your hand for me. Do you affirm that the testimony you're about to give is the truth, nothing but the truth under the penalty of perjury?
yes.
All right, I can see you from the neck up, but it appears that I don't know what type of, okay, you have to go put some clothing on to cover up. Can't,
Okay, I actually have an interview, that's what I was trying to say, I can't speak right now.
okay, well,
And
then
I
you
let the
won't speak
victim
at this
advocate know
time.
that as well.
Okay, that's fine. Then you can get off camera, but you would have to put a top on a jacket or something to cover up. We are in open court.
Okay.
So if you don't want to speak or you don't have time to speak, then we'll let the victim advocate's office or the solicitor give your information or what your statement was to them.
Okay,
All right, thank you.
thank you.
All right. ASG Maguzo, can you give us information she gave to the victim witness advocate or what she wants us to say on her behalf?
Yes, Your Honor, it's pretty much what I stated. She said, confirm all the events in the warrant. She said the incident location is her home. That's for the incident on the 25th.
Okay. So you have nothing different to say. I heard all of that. So
Yes, yes, Your Honor.
this is quite extensive. All right. Let's keep moving. I'm sorry, Attorney McLeod.
Yes, Your Honor.
Okay.
I would ask the court for signature bond for my client. My client has no criminal history other than some traffic-related offenses. He's absolutely not a violent person. He tells me that he has some college education. He went to UGA and he is gainfully employed, Your Honor. He denies the allegations. He tells me that the dispute started because he had a safe and the alleged victim broke into his safe and took some money which belonged to him, $500. And when he confronted her about it, they got into an argument and she kicked him. That is how it all started. As I said, he has no history of violence, Your Honor. So I think a signature bond he's qualified to get a signature bond. He's okay with no further contact with her. I would have asked the court for a one-time police escort for him to go back to the location, but then I actually had the opportunity to speak with the victim, and she says she gave all of his belongings to his brother. That's what she told me. But I did tell her I would still ask because I believe my client said he had some stuff there. He actually was in the process of packing up to leave when all of this happened. So I think a one-time police escort would be appropriate. She did indicate that she had applied and received a TPO, so of course it will have to be a law enforcement officer. But I think my client should at least be entitled to that one-time police escort just to get his belongings, and he's perfectly okay with no further contact with the victim. I do want to point out that even the state in their narration says that he called her from the jail. He did not make any threats to her or anything like that. Even when they said that they were engaged in something and he had two guns and brass knuckles, there's no indication that he used any of those things or threatened to use any of those things, because he's not a violent person. Nothing further, Your Honor.
So he will be leaving the location.
That is correct, Your Honor. He said he was in the process of packing up his belongings. And she said she gave his stuff to his brother. That's what she said. But I think it would be appropriate, since they had been living together, for him to at least have a one-time police escort, because she probably couldn't find every single thing. If you've been living somewhere, I don't think that's an unreasonable request for him to have this opportunity to go with law enforcement to get his stuff.
All right, I hear you, but I'm a little concerned with some of the allegations and allowing him to go back. I think certainly he needs to check with his brother to see if his items are there. Then he may not have a need to go back. But let me see what I'll do first for the bond. I don't know that I feel as comfortable with Mr. Wortham having a signature bond through pretrial. I see it was just, he's got 7 cycles, but
All traffic related, Your Honor.
all of them were traffic.
Yes,
Do I
Your
see a
Honor.
2020 FTA?
Yes, Your Honor.
And he's got 1 FTA from 4 years ago. All right, I'm going to order that 13,000 signature bond through pretrial level 2. And that'll be 5,000 on the battery family violence, 3,000 on the 2 simple batteries each, and then 2,000 on the criminal trespass. And the reason why I'm making it a very high signature bond through pretrials in hopes that he's done with whatever's been going on. But if he violates, he'll come back in at 13,000 plus. Or obviously a stay away from that incident location, or from anywhere that Miss Sierra Bell may be. He's had no further contact with her by any means. No social media post about this incident, about her. No contact with anyone related to her, her brother, cousins, third parties. Not to have any contact with them as well. So stay away from her job, where she lives. Be 200 yards away from her, which is 2 football fields. If he has any weapons in his possession or in his home, he needs to turn them over to the sheriff's department immediately or upon his release. And he can have a one-time law enforcement escort back to the location if he determines that he has anything still there. I'll suggest he check with his brother first. And if so, then he needs to arrange to have law enforcement go back with him. Do not go back alone. No drugs, alcohol, weapons, or guns while on bond. I think that's it.
Your Honor, repeat those bond amounts?
5,000 on the battery family violence, 3,000 on each of the simple battery family violence charges, and then 2,000 on the criminal trespass.
Okay, thank you.
It should
Thank you,
total
Your Honor.
13. All right, thank you.
Mhm.
Position number 2, Blackman.
This is 25 CR 001580Y. Demonte Blackman charged with 2 counts of battery family violence, 1 count of cruelty to children in 3rd degree.
He got 10 total.
Okay.
Yes, Judge. This incident took place.
Hold on.
Oh, go ahead.
He got 10 total. 2025 possession of a Schedule 1 controlled substance. 2022 battery DV dismissed. 2022 battery trespass that was DWAP. 2016 possession of a controlled substance. And he's a resident out of Nashville, Tennessee. That's all.
All right. ASG.
That's, sorry for cutting you off there, Mr. Howard. So this incident took place on November 30th, 2023, Judge, at an apartment complex located at 925 Canterbury Road, Atlanta. Officers responded to the location and upon arrival were approached by a neighbor, actually, who stated that they'd heard someone calling out for help from the apartment. The victim, in this case, Miss Shantia Mathis, explained that the defendant, who's the father of her child, had gotten into a verbal dispute with her over the disappearance of her vehicle. This dispute turned physical when the defendant grabbed her by the arms, began to strike her, at one point causing her face to hit the wall and throwing objects at her as well. She sustained a bloody nose and scratches to her arms, face, and upper lip from the attack, which the officer observed. Juvenile SB are the initials, who is the child of Miss Mathis and the defendant, was only a few years old at the time and was present and witnessed the incident. The defendant then fled the scene. With respect to convictions, I'll go into just briefly. There was a possession controlled substance charge in 2018 out of Tennessee. He pled nolo to driving while license suspended or revoked. I believe 2019, could be wrong about that, apologies. And his open cases, there is one, he was arrested a week ago for possession of a Schedule 1 controlled substance out of Catoosa County, Georgia. But this is what I'd like to get into, the prior arrests for the defendant. There are 3 prior arrests for battery family violence, as Mr. Howard alluded to, all of which were with the same victim, Miss Shantia Mathis, and all of which were dismissed. Tragically, I would say, for one reason or another. Completed pretrial diversion for one, and then it was dismissed. Clearly didn't learn from that. And then the others were DWAP'd and null prost, respectively. Just briefly on those, in the August of 2022 incident, he was arrested for biting her finger and striking her in the head and torso, as well as a criminal trespass and damage to property charge for smashing her phone. In November of 2022, he was arrested for putting her in a headlock twice, pulling her jacket around her neck and causing visible bruising as a result of that. And for the incident in 2022, that was December, so just a month after that, arrested for striking her repeatedly in the face, pulling her hair out, causing her to sustain bald spots to her scalp. To this date, he hasn't faced consequences for any of these charges. So it's the state's belief that it's very important that he does so with this incident. We've spoken with the victim Ms. Matheson, based on our contact with her, I anticipate, if she's here today, we'll say that she doesn't want to proceed with this and feels like this is in the past and that things are good now. But, we believe she is now and has been subject to the cycle of violence, and the defendant poses a substantial risk to her safety and as well to the safety of their child. With that, the recommendation from the state is on the first battery family violence count, a $2,000 surety bond. On the second, a $2,000 surety bond, and on the third, cruelty to children, the third, a $2,000 surety bond as well, for a total of a $6,000 surety bond. The state's recommended conditions are for him to actually complete FFIP, to have no further contact with Shantia Mathis, for there to be third-party transport for their child, for a stay away from 925 Canterbury Road, Atlanta, and for there to be no drugs, weapons, or alcohol for the defendant while out on bond. With that, we would ask the court to sound for the victim if she is present.
All right, Miss Shanti Mathis, you're on the line at all?
Yes, ma'am, I'm here.
Do you want to address the court today, yes or no?
Yes.
You do need to turn on your camera so I can see you and swear you in first. All right, raise your right hand for me. You affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right, put your hand down for me. You in fear of Mr. Blackman?
What was that, ma'am?
Are you in fear of Mr. Blackman?
No, Your Honor.
Do you want to have any further contact with Mr. Blackman?
Yes.
When you all have a child together?
Yes, Your Honor.
How old is the child?
My child is 3.
You all residing together?
No, ma'am.
Okay. All right, I don't have any other questions. State, do you have any questions? ASG Sirocco, do you have any questions of this witness?
Apologies, I was muted, Judge. No, Judge, thank you.
All right, and is this your case, Mr. Cloud?
It's my case, Your Honor. This is a rather old case. It's almost 2 years old. My client does not live in Atlanta. He tells me that he's a resident of Nashville, Tennessee. He tells me that he and Miss Mathis are no longer in a relationship, but they do co-parent the child, and that the child lives primarily with him. He was arrested on this warrant because there was a traffic stop. That is how come he was arrested for this. He did not know about the existence of this warrant, Your Honor. I did not hear that he had any kind of convictions or any kind of violence. I did hear something drug related. So I would say that he qualifies for a signature bond. If the court is disinclined to give him a signature bond, I would ask a much lower bond than the state is asking for, Your Honor. I believe they asked for $6,000, I think, under the circumstances. Based on what the alleged victim has said, the age of this case, and, my client's status. He does not, as I say, he does not have any history of any violent convictions. Arrests are not the same as convictions. That is what I would be asking for. A signature bond, maybe at level 2, and nothing further, Your Honor.
I am concerned that he lives out of state, that he will return. And again, he did have the 2 arrests for battery DV, but one was dismissed, one was DUI. They were both in 2022.
There were 3, Judge. Sorry to
Or
correct you.
3. Okay. Where is the third one? I missed one.
There was one for an incident in August 2022, one for November 2022 and December 2022. One of those might be 23, if I'm mistaken, but those are the 3 that I'm referencing.
And then you're not sure who the victim was?
Oh, no, Judge. She was the victim in all three of them.
She's the same victim in all three.
Yes.
Normally, I would say if someone was on bond, they were violating the terms, but I guess he wasn't, since those are all disposed of. I'm going to order the $6,000 surety bond, 2,000 on each of the three charges. I'm going to order that, even though I know this has been, gosh, 2023 November, that he have no further violent contact with the victim. I'm inclined to say no further contact, but maybe it's over and there's no harm that will come to this victim anymore. But I'll do no further violent contact. As far as staying away from the home, I guess, if he's still visiting with the child.
The child lives primarily with him. That's my understanding, Your Honor. But of
Say that
course, mom
again.
has, the child lives primarily with my client. But of course, mom has to see the child, and I would imagine they exchange the child from time to time.
Miss Mathis, are you still there? Did she drop off?
I'm here, Your Honor.
Where does the child live?
Primarily with his dad.
Oh, not with you.
Yes, Your Honor.
So come on camera for me, please.
Okay. I'm here.
Okay. So does the so how often do you have your child?
Like on the weekends, because I'm a nurse. I'm in nursing school, so he helps me out tremendously with our kid.
And he's what, 4 hours away?
Yes.
All right. I hope that there won't be any more incidences after that one or any more to follow. So I'll just order the no further violent contact. And they asked for a third party transfer. Do you all do that, or how do you all transfer the child?
I would like to ask, maybe we don't need a third party transfer because we've been
I guess
doing,
have you been doing it all of 2024 and
we've been
now
fine.
and you haven't had any incidences? Sometimes I get fearful because after court, people don't like what they heard, and then they begin to discuss it or talk about it, and things can churn up sometimes. So hopefully that will not be the case. But I'm sure you know to call the police if something happens. But I won't because of the, out of town transfer and all that. If you all have been, getting along fine, I hope that's what happens going
Yes.
forward. So
Yes.
I'm not gonna order the third party transfer at this time. Just the no further violent contact. So if it gets violent, call the police.
All right.
No drugs, alcohol, guns, or weapons while on bond, Mr. Blackman. And I guess that's it. Did I miss anything?
I don't think so, Your Honor.
Okay. All right. Thank you.
Thank you, Your Honor.
Uh-huh.
Judge, before we move on to the next case, could I briefly bring up position number 4? It was Mr. Hayden Ferguson. I wanted to touch on this. I can't recall which attorney represents Mr. Ferguson.
That's my
but-
client.
Okay, and private, right? Or no?
Yes, private attorney.
Okay, I just wanted to make sure we didn't leave this outstanding in case whatever the case. But we would just request, and I'm not sure how the defense feels about it, but an MH evaluation for this case.
We'll have to go into to the breakout if we're going to talk about any MH issues on position 4 or any other position for that matter, depending. So
Okay,
we usually discuss that in a breakout.
right.
And
I
he's
just wanted to
represented
know.
by Cameron. Is it Sally?
It's Salih, Judge, for
Salih,
Scott
I'm
Smith.
sorry.
Yes, Judge.
Salle. And you were Scott Smith.
Yes, Judge.
All right. If that's going to be part of the request on that will need to go into breakout. And is this him before us, Mr. Ferguson? Who's before us, deputies?
This is position 3 before us.
Oh, not 4. Okay. All right, this is position 325 CR 001567A. Isaiah, is it Brady or Brady? Charged with 1 count of battery, family violence, 2nd count cruelty to children, and the 3rd pre-trial.
Or total. On probation out of New Jersey, death by unlawful taking. It was some violent charges with that arrest, but they were dismissed. 2024 obstruction, dismissed. That's it.
All right, state.
Yes, Judge, this incident took place yesterday, March 25th, 2025 at 765 McDaniel Street, Southwest Atlanta. Law enforcement was dispatched to the location on a fight call. Upon arrival, the officer made contact with the victim, Miss Sanaya Burgess, and that's spelled Saniya, Burgess, Burgess, who explained the defendant, who's the father of her child, juvenile YB, had showed up to Miss Burgess's mom's house where she lives. He came unannounced and confronted her over cheating allegations after seeing some text messages that he did not like. He punched her in the nose as she was holding their child, YB, causing it to bleed. She then ran into her room and locked the door, but he proceeded to kick the door in, wrestled the child out of her hands in a scuffle that lasted for roughly 30 minutes, at the end of which she eventually let go of the child because she was worried that YB would be hurt if she didn't. The defendant then ran outside with the child and tried to get away via lift before the Lyft driver declined to drive him, at which point the defendant fled, running on foot with the baby in hand. The officer observed the dried up blood surrounding the victim's nose, as well as blood spattered on her clothes and the bathroom floor. Thankfully, the defendant's mother actually returned later with YB, dropped him off, where he was checked out by Grady Medical and was determined to be unharmed. With respect to his history, just to elaborate on what Mr. Jordan had remarked on the 2023 arrest, for which he was convicted of felony theft by taking. He was also arrested on charges of ag assault, causing substantial bodily injury, conspiracy to commit robbery, endangering an injured victim. And with that, Judge, the state's recommendation is for count 1, the battery family violence, a $2,000 surety. And on count 2, a $1,000 surety. And with the conditions of anger management, a parenting class, no further contact with Sanaya Burgess, and a third-party transport for the child, as well as a stay away from 765 McDaniel Street, Southwest Atlanta, and no drugs, weapons, or alcohol while out on bond. And if Ms. Burgess is on, the state would ask that we sound for her at the appropriate time. Thank you.
Do we know how old the child is or not?
I believe very young, roughly, I think maybe 3 years of age, if I'm not
Okay.
mistaken.
All right. And Sanaya Burgess, I don't believe is on. Sanaya Burgess. All right. PD, is it Haddad?
It's me, Judge. Thank you. Judge, on behalf of my client, Mr. Brady, he's 20 years of age, Judge. He's a high school graduate, lives with his mother here in Georgia. He is employed at Jenny's Ice Cream. A stay away, I think, is appropriate, and perhaps a one-day anger management class is also appropriate, Judge. We would just ask the court to release him through pretrial services, whatever level that the court seems appropriate. I would note, I mean, he has a conviction for theft, and that's all that should count, Judge, not, allegations of violence. So in front of the court right now, he doesn't have any prior violent convictions, Judge. If the state felt so strongly about it in New Jersey, they should have prosecuted as such. But as it is, it's a charge of theft by taking, and I would just ask the court. He is eligible to be released through pretrial services, and that's the request of the court. But a stay away is appropriate, Judge. They do not live together, and there's at this point there's no need for any future contact, Judge.
Okay. I will order the $3,000 surety bond. There's $2,000 on the battery family violence, $1,000 on the cruelty to children. I'm gonna order that stay away from 765 McDaniel Street Southwest. No further contact with the victim, Sanaya Burgess. If visitation is allowed with the child, it must be facilitated by a third party. Although I'm not advocating visitation at the moment, but if she allows it, it needs to be a third party. No drugs, alcohol, weapons, or guns while on bond. And that's all out order at this time. $3,000 surely.
Next is position number 5. Mr. Jenkins.
$25 CR 001569C, Perry Jenkins, charge of 1 count of battery family violence, pretrial.
44 total. You got an ag assault, cruelty to children, battery, opening Superior Court. It's 25 SC 000650. Open case out of Clayton County, theft by receiving 2 counts. Possession of cocaine with intent. 2022 probation, 2019 battery DV arrest. 2018 theft by receiving NOLO. 2012 ag assault, false imprisonment conviction. That's it.
Okay.
Yes, Judge. This incident took place at 1631 Stanton Road, Southwest Atlanta, on August 6th, 2024. Law enforcement responded to the location regarding a dispute call where they made contact with the victim, Destiny Stedman, Steadman, who explained that she was in a verbal dispute with her boyfriend, Mr. Perry Jenkins, that turned physical when the defendant grabbed and ripped her wig, causing her hair to be detached from her scalp. Leaving bald marks where the strands of hair were removed. The defendant fled the location prior to the officer's arrival, and both the defendant and Ms. Stedman reside together at the location at the time of the incident. Briefly, with respect to criminal history, there are convictions for false imprisonment, aggravated assault, receipt, possession, transport of a firearm by a convicted felon or felony first offender. That was 2012. Possession of a cocaine with intent to distribute, 2018. He pled NOLO to felony theft by receiving in 2019. Convicted of giving false information to law enforcement and possession and use of drug-related objects, 2019. And there was also a reckless driving conviction, which was amended from fleeing and eluding in 2024. There are a few drug arrests out of Florida, and one out of Alabama, I believe, for obstruction, tampering with evidence. But with respect to his Georgia arrests, he was arrested for battery, family violence, obstructing or hindering persons making emergency phone call, criminal trespass. That was in Clayton County. Those charges were null prost, and as Mr. Jordan stated, probation violations in the last 10 years for 2018, 2022, and as well the open case of ag assault family violence. This is with a different victim, the mother of his child, but a different victim, and 2 counts of cruelty to children in the third. Now it is my understanding that Ms. Stedman will be on Zoom today. So we would ask that the court sound for her when appropriate, but given the history and the facts here, the state's recommendation is a $2,000 surety with no further violent contact with Ms. Destiny Stedman, anger management, and no drugs, weapons, or alcohol while out on bond. That is all.
Okay, Destiny Stedman. Destiny Stedman on the line. Don't see her. All right, go ahead. PD McLean, is this you?
Yes, Your Honor. Perry Jenkins is 46 years old and has an address on Northside Drive at an apartment complex well away from the incident location. The jobs that he's had, the career he's been having is driving a truck over the road for several years. We understand what the recitation was of the arrest record, but Your Honor, we would ask the court to consider looking at the facts and allegations of this case to consider a signature bond, and if not a signature bond, a bond that is a surety bond no higher than $1,000. Thank you.
Your Honor, I'm here. Destiny Stedman is available.
All right, would you like to address the court today, yes or no?
No.
Okay, all right. Then you can mute yourself. I'll give my ruling.
Okay.
Thank you. All right, I'm going to order a $3,000 surety bond. And I'm going to order that Mr. Jenkins have no further, the state, you asked for no further violent contact?
Yes, Judge. She had stated to our office that this kind of thing hadn't happened between them before, and that she wanted contact with him. So that was our recommendation, but if you see it differently, love to hear that as well, Judge. Thank you.
All right, well, I see this is from August the 6th of 2024. Assuming there have been no recent incidents, I'll go with the no further violent contact. And did you ask? Well, I guess we don't need to stay away if he does not reside there. What's the state's position on that?
They no longer live together, Judge. And if I neglected to include the stay away, I apologize. We are asking for a stay away from 1631 Stanton Road, Southwest Atlanta.
So I'll order a stay away from that address. No further violent contact, no drugs, alcohol, weapons, or guns while on bond. And 3,000 surety. I think that'll be it.
Position number 11, Thunder.
This is 25 CR 001571B. Otis Ponder, charged with 1 count of theft by shoplifting, 2nd count criminal trespass and damage to property. Pre-trial.
20. On probation out of car, theft by receiving. 2025 probation. 2022 theft of lost and mislaid property. Possession of drug-related objects conviction. 2022 trespass conviction. Another 2022 trespass, possession of drug-related objects conviction. 2021 trespass conviction. 2020 shoplifting conviction, 2020 shoplifting trespass NOLO, 2019 man, that should be a felony. 2019 shoplifting conviction, 2018 shoplifting NOLO. I stopped there.
Yeah, that's fine.
This is my case, Your Honor.
Okay.
This incident happened on March 24th, 2025 at 1990 Donald Lee Hollowell Road. It's a BP gas station. The officers met with a store clerk, who advised that the defendant entered the store, picked up a 12-pack of Coca-Cola, and left out of the store. At some point, he damaged the front door entryway of the store. Officers were able to spot him in the parking lot and place him in custody. He had previously received criminal trespass warnings twice from this property. The state is looking for a $2,000 signature bond through pretrial based on his history at anti-theft course, if you're inclined. A stay away from 1990 Donald Lee Holloway, the BP gas station, and no drugs, alcohol, or weapons while on bond.
All right. Mr. McLean's your case?
Yes, Your Honor, thank you. Otis Ponder is 29 years old. He's from Georgia all his life. He went through the 10th grade at high school, at Carver High School. And he makes a living by doing odd jobs for people, doing house repair, washing cars. That would include landscaping and all sorts of vigorous activity. We would ask the court to consider a signature bond in this situation. And if not a signature bond, then a 1,000 surety. Thank you.
I will order a $2,000 signature bond through the jail. 1,000 on each of the charges. Stay away from the BP on Donald Lee Hollowell. Stay away. Or else you'll be back here. So please don't celebrate too quick. All right. So with that, stay away. No drugs, alcohol, weapons, or guns while on bond. And that'll be it.
Number 12, Scott.
25 CR 001570 Justin 70Y. Justin Scott, charged with 1 count of simple battery, family violence.
It's his fourth arrest. He had an arrest out of California for annoying phone call conviction.
All right.
This is also my case, Your Honor. This incident date happened on September 18th, 2023 at 745 Fountainhead Lane, Northeast in Atlanta. Officers were dispatched to location. They spoke with the victim. I believe her name is Josephine, Josefine Vargas, Vargus. She stated that her and the defendant, who were boyfriend and girlfriend, recently broke up. They made an agreement for her to come by and pick up her things from his place. She stated while he was there, he began to verbally abuse her by her neck when she was on the floor taking a desk apart. Officers did have a chance to speak with the victim. She said they're no longer in a relationship. They don't live together. They share no children. She stated she was on the floor taking her desk apart when the defendant was trying to talk to her. She didn't want to talk. She stated that this angered the defendant, and as her back was towards him, he grabbed her by the back of her neck and pushed her down. She said that she was scared and ran out of the house. She stated months after the incident, he has texted and emailed her to apologize, and she hasn't responded. She stated she is in fear of the defendant because she is afraid that he will retaliate. She stated that he has been violent with her in the past, and she didn't call the police. She did state that her and the defendant attend the same gym, and she's afraid she may run into him. She wants no contact, and she may be on Zoom so we can sign for her when appropriate. The state is looking for a $2,000 surety bond on this case. No further contact with Miss Josephine Vargas. I believe the apartment is his, so a stay wait isn't necessary. 1 day anger awareness and no drugs, alcohol, or weapons while on bond.
Okay.
And Judge, this is my case. I don't have any objection to the bond amounts and conditions. Mr. Scott is 43 years old. He actually dental practice. He has 2 locations. He's lived in Georgia for, over 15 years.
You froze
And
on me.
this
You
is
said he
his.
was, hold on a second. You froze on me. You said he was 43 years old and had something, and I missed that.
I'm sorry, Judge. Can you hear me now?
Yes.
He owns 2 dental practices.
Oh, okay.
Or excuse me, 1 dental practice with 2 locations. And from my understanding, he hasn't had any contact with his, I believe it's his ex-fiance in the past 2 years. So we would not object to any conditions regarding no contact.
All right. And the victim, I assume, is not on this call. Josephine Vargas, I think. No. All right. I will order the $2,000 signature bond through pretrial. This is restricted charge, isn't that correct? ASG?
I believe so, Your Honor.
It has
It
to come
is.
to
What's the level?
level 1. And with that, I know this happened in 2023, I believe.
Yes, Your Honor.
I'm assuming is having no further contact with Ms. Vargas. Stay away from, is that Fountain Hall, supposedly her address? Stay away from wherever she,
It's his, Your Honor.
I'm sorry?
I think this was his address, the Fountainhead Lane,
Oh,
Northeast.
that's his address.
That's correct.
Oh, okay. So just stay away, no further contact from Ms. Vargas. Stay away from wherever she lives or works. Don't go within 200 yards of her, which is 2 football fields. And no drugs, alcohol, weapons, or guns while on bond. I think that'll be it.
Thank you, Judge.
Number 13, Thomas.
25 CR 001568D, Rontarius Thomas, charged with 1 count of battery family violence, a 2nd count of simple battery. Pre-trial.
It's his 5th arrest. He was arrested earlier this year for disorderly conduct, terroristic threats. 2019, no insurance, no license conviction. He's already out on pretrial. So.
Oh. Okay.
And this is also my case, Your Honor. This was a dual arrest. We did NOD the co-defendant in this case, who we believe to be the victim. This incident happened on March 25th, 2025 at 1410. I'm sorry, 397 North Central Ave in Hapeville. That's the Signal Apartments. It was an unidentified female caller who called officers. They first went to the wrong apartment because she said she heard screaming. Officers left and came back. They met with, we said, the victim in this case, which is a Cameron Levy. Cameron is spelled Kameron. Levy is Leavy. He answered the door for officers and stated that him and the defendant had gotten into a disagreement. He had several marks and scratches on the left side of his face and his neck, and scratches on the upper body part of his chest. Officers asked him what happened. He stated that they had a disagreement. He stated that he fell, and that officers let him know that his injuries weren't consistent with just falling on the ground. They did speak to the defendant as well, who stated there was a disagreement, but there was no punching involved. And officers let him know that the marks had to have come from a physical altercation. The state is looking for a $2,000 surety bond in this case, a stay away from 397 North Central Ave in Hapeville, no further contact with the victim at Cameron Levy, 1 day anger awareness, and no drugs, alcohol, or weapons while on bond.
All right. PD McLean.
Your Honor, Rontarius Thomas is moving here to Georgia from Memphis, Tennessee. He and the other person are cousins. They're both from Memphis. And he went to high school in Memphis, and his job is with FedEx for a couple of years, driving tugs, those vehicles that are on the apron of the airport. Your Honor, we did read the police report really carefully about the injuries involved, and we understand why the police officers arrested both, but it is the prerogative of the state to drop one of them if they want to. Your Honor, we would ask the court to consider a signature bond. He knows how to stay away from his cousin if the court orders it. If there's no further violent contact, that's one thing, but if there's no contact whatsoever, he understands how to do that. He will find another place to stay. He's 25, he's young, and he's got prospects. Thank you.
Your Honor, I just want to further reiterate, I missed the line of this, that Mr. Levy did state the defendant choked him. So we're going to further request that no further contact.
And Cameron Levy, the cousin, was the co-defendant at the NOD, the case.
Correct, Your
Same
Honor.
person. Okay, making sure it's the same person. All right, I'm going to, I know that he only has the 5 cycles, but what was the date of the arrest for the disorderly and the terroristic threats?
I think it was February. Hold on. I just had it up. Let me pull it up.
Because that's 2025.
February 17th.
Oh,
A
do we
little over
know
a
who
month
that?
ago.
Right. Do we know who that victim was at all? No.
Your Honor,
Uh,
may I say something about this since I actually spoke with Mr. Cameron Levy? I was supposed to be representing him. I did not know his case
Oh.
had been NO'd.
Oh, you did not. Okay.
Cameron Levy.
Oh, Cameron Levy was
No
the victim
weapons,
in
no
that case.
drugs without legal prescription or alcohol, and no further violent contact with Cameron Levy. Leavy.
Oh, who was the judge on that?
Superior Court.
Oh,
Judge
Superior
Locke.
Court. Oh,
Well,
Superior
magistrate,
Court.
Judge Locke.
Oh, magistrate. Okay.
Yeah.
I thought it was state court. Okay. All right. Go ahead, Attorney McLeod.
Yes, Your Honor, I actually spoke to Mr. Cameron Levy, and he tells me that they were just playing a game. They were up late playing some video games. He said that there was nothing violent between them at all, but he believes that the neighbors may have called because they heard the noise and they were slapping things around. That is what he told me.
Your Honor, Mr. Levy's not on our docket, and you just heard from pretrial and the state that he's the victim in the case that this gentleman is out on bond for. So at this point, it's just in Mr. Levy and this gentleman's best interest that they not be living in the same house together.
And tells me, well,
your client's not here. He's out on bond. We
understand.
appreciate it.
He's
At
not
this
out
point,
on
like,
bond. I talked to him today. He was
why are we
arrested
addressing this
also
fee?
because I
He's not
think
here
it's
to answer these questions or
Miss
talk about this.
Allen, respectfully, I do believe it's important that the judge has the full picture as to what happened in this arrest. They were
I
actually
understand that that's your position,
arrested
but your full
yesterday.
picture is often very biased, and we don't have a victim actually here who we now perceive as the victim and is the victim in an open case to actually talk to the judge about this.
No, I
All
spoke
right.
to him. I just
All
wanted
right,
the
we'll
judge to
move
have the
on.
full picture. That's all, Miss Allen. Since I was actually waiting here because he was on the docket earlier. I spoke to him today at the jail. I was going to represent him. So, of course, I talked to him at length about this incident. And I think it's important that the judge understands what happened. That's all.
All right. But I am concerned that he is the victim on the other case just from February, a month ago. That does concern me. And so I don't know what's going on with him and his cousin. They either play terribly rough or shouldn't be together so that they don't get in further trouble. I'm going to order because also he's moving here, hasn't moved here. I don't know if he still lives in Memphis or he's in between. So I want to make sure he's going to come back to court. So I'm going to order the $2,000 surety bond, $1,000 on each of the charges. And I'm going to, with that surety bond, I'm gonna order no drugs, alcohol, weapons, or guns while on bond. I'm going to order him to have no further contact with the victim, Cameron Levy. And that Central Avenue address, do we know whose apartment that is, or is that where they shared an apartment?
That's where they shared an apartment. It is a large building with a lot of young people starting off, oftentimes students.
Well, he's gonna have to find somewhere else to live right now while he's on bond. I want to make sure that these two incidents are behind them, if they are. And this just happened yesterday. So I'm gonna order a stay away from that location. He needs to find somewhere else to go live in the meantime. Have no further contact with Cameron Levy. No drugs, alcohol, weapons, or guns while on bond.
Let's go to number 15, trolling.
$25 CR 001574 E Spencer, I don't know, troll line. Charging one count of battery family violence.
First.
Retrial. Date.
Yes, Your Honor. This incident is from March 25th, 2025. The location is 640 Branch Valley Court, Roswell, Georgia, 30076. On the day of the incident, the victim, Miss Catherine Trolline, and the defendant, Mr. Spencer Trolline, who is the victim's 21-year-old son, got into an argument while the victim was driving. The defendant leaned over and beat her on top of her right arm. The victim called the police after arriving home. Responding officers saw a visible circular red mark that was starting to bruise on the victim's right arm. The victim and the defendant do live together. We were able to speak with the victim, and she told us that the defendant has some ongoing MH issues. Part of my recommendation is going to bring that up. And I know the victim is here and she wishes to speak. So I don't know if you want to go in a private room or.
Depends on what she's gonna say. I've heard your recommendation. And Miss, is it Trolline? Or
Lean.
Trolline?
Yes, ma'am.
Rolene,
Do
my
you
apologies.
Do
okay.
you wish to address the court today?
Yes, please, I would.
Okay, I'd like to swear you in. Are you gonna talk about any MH issues?
I can be general.
Right, as otherwise we'll have to go into a breakout, and I don't usually discuss any of those issues in open court.
It might be hard to avoid it. It might be best to go into breakout.
Okay.
Thank you for the recommendation.
Ms. Bridgewater or someone else?
It's Miss Grace, Judge.
Oh, hi, Miss Grace.
How are you? You want to go in a breakout room?
Yes.
Okay,
Yes,
who all?
please.
Okay, who all is going in?
McLean, Melguzo, do you want to go in, Ms. Dunlap?
If I could go in as well, Judge.
And Ms. Allen?
Thank you.
Before you go into the breakout-
Everyone in the ASG's office, huh?
Before you go into the breakout, I would like to ask about Aaron Lewis. He's not on the calendar. Is all his charges upgraded?
Yes, his case went to felony court. Those were upgraded, obstruction felony and terroristic threats felony.
Thank you.
Before we go into the breakout, Mr. McLean, is Miss Moorhead your client as well?
No.
That's Mr.
She's mine.
Okay.
Okay, you ready, Judge?
Yes.
Mr. McLean, is this your client?
Miss Shoreline, yes.
Okay.
Mr.
Yes.
Attorney Sally, Attorney Cameron Sally.
I'm here. I'm sorry about that.
No problem. Judge wants you to come into the breakout room. I'm going to send you in.
Okay, perfect.
Mr. Haddad,
Yes.
Judge wants you in the breakout as well.
All right, sounds good. Thank you.
Courtroom 2.
Yeah.
Let me get the bun amount for 11 and 12, please.
I already get turned that paperwork in. Who is position 11 and 12?
You already turned it in.
Yeah, but who are they now? Probably.
Ponder, Scott. Yeah, 13 too, Thomas.
Hold on.
Oh, they back now.
All right, let's update as to where we are. From the breakout. The first case from the breakout, what number is it?
The first case was position number 15. Mr. Spencer Droling or Drawling?
Truly.
Droling, okay, well, that's him.
All right, this is 25 CR 001574E. And we were in the breakout, and the order of the court would be a $3,000 signature bond through pretrial, level 1. And pretrial, I'd like for him to be a call-in because he will probably be somewhere undergoing some other matters. He is to comply with any treatment and medication that may be ordered by anyone who his physician. He is to have no further violent contact with his mom, Katie Trolling, and being compliant with what needs to happen to assist him. No drugs, alcohol, weapons, or unprescribed medication, guns or knives while on bond. And I think that's it. Anything else, State?
No, Your Honor. Thank you.
All right. And so you're free to go, Ms. Trolling. Thank you so much. Hold on 1 second. She can go.
Can we do it, number 18 Williams next, or y'all gonna do the other breakout?
All right, sorry about that. All right, what were you saying, Ms. Bridgewater?
This is position 18 right here before you.
Okay. Do we need to update them on the other case
Um,
that we did? I was gonna put it on the record for the other one.
okay, I think the other one was number 4, Mr.
Miss.
Ferguson. It's the other. And then Miss
It's, hold on.
Moorhead, I believe was her name. We
Right.
need 4 and 7 updated.
All right, let me give update on position 4. Hayden Ferguson, 25 CR 001507F. The ruling is a $500
Per charge.
per charge for a total of $2,000.
SOB through the jail.
Thank you. I can't even read my own handwriting.
That's okay. And he's to be released to Christy Ferguson.
Yes, his mother, and he is to comply with any and all treatment and medication that may be ordered or that may be required, rather. He is to stay away from the Starbucks at 609 Holcomb Bridge Road in Roswell, not to go back there, and no further contact with Stephanie Mateer at North Fulton. And I believe that was all that I ordered.
And he
unless-
had a MHET.
Oh, MHET. I'm sorry. Yeah, that was. All right. And that's it on that case. And then the other one was 7.
Position number 7, LaWanda Moorhead.
Right. 25 CR 001576J. And charged with criminal trespass and PI. That will be a $1,000 signature bond through the jail, $500 on each to be released to her hold in Cobb. We're asking for a social worker visit and
Stay away,
from the incident location.
which is 4215 Wendell Drive.
And I think that's it on that case.
Mm-hmm.
Okay. And now, before us,
where's it going?
hold on.
Okay.
Okay.
Ah,
No, come back. All right, this is position
18.
Jaleel Williams, 25 CR 001577E, charge at 1. Oh, maybe that wasn't Mr. Williams. Are you
It was a woman, wasn't it?
Who's Jaleel Williams?
He's in front of you now.
That's what I
Oh, okay.
thought.
Okay, thank you. Charge of 1 count of willful obstruction, law enforcement officer. Pre-trial.
4th arrest. You got to open battery theft by taking. That's a pretrial bond too. 2018 possession of a controlled substance, marijuana and drug related objects. You got PTI.
Okay. State.
Yes, Your Honor. This incident is from March 24th, 2025. The location is 5003 Cypress Court, Alpharetta, Georgia. On the day of the incident, Officer Hamby from the Alpharetta Police Department was trying to issue notice on the defendant, Jaleel Williams, regarding a different matter. Officer Hamby knocked on the door and announced himself. A male opened the front door, and Officer Hamby could hear a female yelling and what sounded like a struggle from inside the residence. The officer then entered the home and saw the defendant attempting to flee through the back door, while another person in the house was attempting to keep him inside. The defendant made it through the back door and started to climb the patio fence in an attempt to escape. The defendant stumbled after climbing the fence and fell to the ground, and officers were able to put him in handcuffs at that point. The state's recommendation is a $2,000 surety bond no alcohol, drugs, or weapons while on bond. And the reason we're asking for a surety, it's because he does have those 2 open cases, one for battery and another one for theft by taking.
Who's representing him?
I do.
Okay, we're ready.
Okay. On Jaleel Williams, Your Honor, he was at an apartment complex and the officer was there to issue him a criminal trespass warning since he was there to issue a warning, when the guy was apparently being held. When I read the police report, it was just like the assistant solicitor read it. Somebody was trying to hold him and he was trying to get out. And then he went over a fence, stumbled, and then they handcuffed him. I was scratching my head a little bit about the crime of getting away from an officer who's there not to arrest, but rather to issue a warning to leave. But we would ask for a signature bond, Your Honor. He is 28 years old. He's worked at Wendy's, McDonald's, Michael's Crafts Art Store, and Chipotle's. He went through the 10th grade. And like I said, he's 28 years old, been in Georgia all his life. Thank you.
Your Honor, you're muted.
My concern is the pretrial bond that he's already on. That will be revoked. So I will order a $1,000 surety bond. Stay away from the incident location, or I guess, I don't know, to order that, maybe not. What do you say, State?
Your Honor, the affidavit for arrest, it was a little weird. I don't believe the address where they were trying to serve notice on the defendant is the same address that they wanted him to stay away from.
Oh, okay. That probably makes sense. I don't know if we have an address. We'll just say that the 1,000 surety, if we don't have any other information, we just don't have it. No drugs, alcohol, weapons, or guns while on bond.
Sounds like a plan to me.
You know, I would have to see. Yeah, the way it reads is I was dispatched to 5003 Cypress Court to issue a criminal trespass on him for the IMT Alfred Apartment Complex. We don't know if IMT Alfred Apartment Complex is 5003 or not.
I looked it up and it's not.
It's not, okay. Yeah, I don't, if they weren't any clearer on it, state investigate. If not.
I guess my was if you're just issuing a warning to somebody, you're giving them notice. You don't yet have the right to arrest them. So when they run, I don't get it. But thank you.
I know. I'm sure you all will sort that out.
Your Honor, I do have the address for the IMT Alpharetta Apartments if we want to put it on record. They were trying to serve him with a criminal trespass.
Warning for that complex. Okay.
Yes,
well,
stay away
let's
from
do that at least, I guess.
Yes,
as
stay away
long as
from
he
the
doesn't live there. Mr. McLean, you don't believe that he lives at that IMT whatever complex, do you? Okay.
No. So I think anywhere as part of this, the officer was there to tell him to stay away from there. Have the reason why, so that would be a different matter, right?
Right. Okay. And give that address. You have that, Ms. Bridgewater, or you need it?
No, because are we doing a state? Okay. Do you want me to add the stay away on here, or are we just going with the $1,000 good bond on the willful obstruction?
I don't know that I feel comfortable. Do I have enough information to know that that's it? I think Mr. McLean is kind of saying it, but I'm feeling a little indifferent about it? Are we sure that, if
Yeah.
you're sure that's what it was, then fine. But if you're not, I don't want to put him to stay away from there if that's not what the stay away was about.
So the warrant was a notice of criminal trespass.
Okay,
IMT Alpharetta Apartments is 3500 North Point Parkway, Alpharetta, Georgia, 3005.
okay.
But now, I just have one charge on here as willful obstruction. Are we doing a criminal trespass? Am I adding that?
That's
or-
not the charge. No,
Yeah.
she's reading that that's what they were serving upon him.
Right.
But then, wow, do we order him to stay away too?
I think you can absolutely say he needs to stay away from the location they were serving him with the criminal trespass on, and he obstructed. We don't need to file a separate charge unless he goes back there.
Well, but that's not,
Yeah.
I guess the problem is where he was picked up from is not the IMT whatever apartments, correct? It's not, it's a different
That's
address.
what I'm trying
We
to.
just want him to not go back to wherever they were saying they were serving him for in
Well,
Alpharetta.
but he's not been, I don't know that we are sure about that to know that that's that, right? Because then to me that the charge would have been,
No, because I think their thoughts are they're criminally trespassing him and giving him notice not to come back. They're not charging him with being there for an unlawful purpose or coming back after not being told to. They're charging him with obstruction because of his behavior during the police encounter.
right.
So he's now on notice. He can't go back there. And if that's included as part of his bond, then that's just duplicative. We're not adding a charge to him today. Now he's on notice that he cannot go back to that location, which is also in Fulton County. And if he does, there will be charges.
Right. My problem wasn't seeing this as an obstruction, but
All right, let's add the address.
Okay, I'll add it on here.
Thank
Okay,
you.
no
I
problem.
get it.
Okay. Are we ready to go over the calendar?
Yes.
I think that's
Okay.
it.
All right. Once again, the reset date for the SAP calendar is going to be April the 8th. Position number 1 is reset further notice as the defendant has been released. Position 2 is going to the SAP calendar with a total $6,000 good bond. Position 3 is going on this SAP calendar with a $3,000 good bond, and that's a total of a $3,000 good bond. Position 4 is reset further notice with a total of a $2,000 SOB through the jail. 5, SAP calendar with a $3,000 good bond. 6, reset further notice with a total $5,000 SOB through pretrial per judge. 7, reset further notice with a total $1,000 SOB through the jail. 8 is reset further notice with a total $2,000 SOB through the jail. 9, reset further notice with a $3,000 SOB through the jail. 10, reset further notice with a total $3,000 SOB through the jail. 11 is reset further notice with a total $2,000 SOB through the jail. 12, reset further notice with a $2,000 SOB through pretrial. 13 is going to the SAP calendar with a total $2,000 good bond. 14 is being reset further notice as the defendant has been released. 15, reset further notice with a $3,000 SOB through pretrial. 16 is reset further notice with a total $5,000 SOB through pretrial. 17 is reset further notice as the defendant has been released. 18 is going to the SAP calendar with a $1,000 good bond. And 19 is reset further notice with a total $13,000 SOB through pretrial. Are there any questions, comments, or otherwise?
what was 5 again?
Let me get to that. Position number 5 is, 1 second, going to the SAP calendar with a $3,000 good bond. Are there any others?
Nope, that'll do it for me.
Anyone else?
Anything else from the state? Nope. All right,
Okay.
thank you.
Thank you.
Appreciate you all.
Thank
All
you,
right.
everyone.
All right,
Yes,
bye-bye.
take care.
All right, bye-bye.
Judge is on his way to you.
Yes, ma'am.
Okay.